Item number 1, pronouncement of judgment.
We are of the view that the learned trial court has correctly assessed the period of limitation and very rightly come to the conclusion that the suit is barred by limitation. We affirm the judgment and decree dated 13th December 2023, rejecting the plaint and dismissing the suit. The appeal is dismissed.
हो गया अच्छा बस चलो हो गया
Number 2 and 3.
We have held that there is some irregularity in the consideration of the tender, but there is no such illegality or gross abuse of power so as to set it aside. Moreover, the successful bidder has commenced performance of the work under the tender, but there is deprivation of legitimate expectation by Odimar Samsad for consideration of his tender. In the circumstances, it would be just and equitable if Odimar was awarded some compensation for being deprived of his legitimate expectation of being considered to be awarded the contract. The Honorable Supreme Court in so-and-so reported in EIR 84 Supreme Court 1703 has estimated the normal profit in a works contract to be 15% of the value of the work. For this deprivation of legitimate expectation, I would award Odimar half of it, that is 7.5% of the value of the work, that is 21,59,242, to be paid to him by Meghalaya Power Generation Corporation within 4 weeks of this order as compensation. This, in my opinion, would do adequate justice to him and to Taiban Warjari, to whom the contract has been awarded. The award of contract in favor of Taibun Warjari is upheld. The impugned judgment and order is set aside. We have also held that there is no evidence to suggest a cartel operating. The appeals are partly allowed on the above terms and to the above extent. MCs connected with WA 18 of 24 and 20 of 24 are disposed of. Yes, call the list.
Number 4 to 11.
Any notebook is there?
May I please,
Yes,
Lordship? Lordship, if I may make one small submission, Your Lordship, before hearing the matter. Your Lordship
matter?
here. Yes, Your Lordship.
Yes.
Your Lordship, here I am assisting Mr. Venkatesh. He is the conducting counsel for the commission, Your Lordship. If Your Lordship may kindly allow Mr. Venkatesh to appear through VC on the next date, Your Lordship.
Sorry?
He has some difficulty, Your Lordship, to get the VC link, Your Lordship, for appearing today. Humbly pray that he may be allowed to appear through VC, Your Lordship.
Appear through VC?
Through VC.
Yes, certainly. Join him.
Your Lordship, today he won't be able to.
No. This matter has been fixed. Mr. Mitra has come from Calcutta.
And
This kind of
earlier notice was given. Previous notice was given
What is
that this matter will be
This
taken
kind
up for
of,
hearing.
when the matter is called, you say one for adjournment. This kind of latitude cannot be. We can be reasonable, we can be compassionate, but not at the expense of others. Yes, please carry on.
Well, may it please your lordship. Well, this is a very short point involved. I shall argue this particular appeal on a very short point. The issue is whether, my lord, the regulatory commission can impose tariff with retrospective effect. In other words, can the regulatory commission fix the tariff today, saying that it will be effective 6 months earlier? This is the short point involved, and my submission will be.
Mr. Pandey, you are appealing for the respondent.
Mithra can continue his arguments, but the Advocate General, my lords, because of the reference matter before the Honorable Supreme Court,
Upon
he won't be
consultation. No, you be there, Mr. Pandey. I appreciate his predicament in the Supreme Court, but in his presence and in consultation with him, this date is fixed. And Mr. Mitra has come from Calcutta for this purpose. Let
Yes, you can take down the notes of my submissions. Short point, I shall argue. Yes. No problem.
No, Mr. Pandey is competent enough to conduct and conclude it himself.
Yes, I'm sure about it.
Yes.
Well, my submission will be that an act, and your lordship knows this, that an act is always regarded as prospective unless, my lord, specifically it has been made retrospective or by necessary intent when it can be shown to be retrospective. This is the point that I am going to urge before your lordship. Because what happened in this particular case was this, and this is what I am aggrieved about, is that the regulatory commission fixed the tariff, to which, my lord, I have got absolutely no exception I can take. I am not taking any exception to that. But what they have done is this, my lord, in the last order, in the impugned order, they have fixed the tariff with effect, my lord, from 6 months back. In other words, in the month of October, if the tariff has been fixed, it has been fixed with effect from the 1st of April of that particular year. I say that this, my lord, the regulatory commission lacks jurisdiction to do so. This is a lack of inherent jurisdiction. But in fact, my lord, the matter came up before the Honorable Trial Court on two issues. First is whether the regulatory commission has the inherent power to review its own earlier order. And there, my lord, the trial court held that it has got the power to review its earlier order under inherent jurisdiction. I am not questioning that. The second point which was involved in the writ petition was whether the tariff order which had been passed could have had retrospective effect, and on the basis of that retrospective operation, whether the enhanced tariff could have been imposed from an earlier date. This is the issue.
What is the earlier date from which it has been imposed?
It has been imposed from the 1st of April 2024 up to, my lord, 31st March 2025. When, my lord, actually the order which has been passed is in the month of October. 24th October 2024, the order was passed, impugned order, by which, my lord, that regulatory commission had, my lord, fixed the tariff rate with effect for the year 2024-25 with effect from 1st April 2024. I am questioning that. I am saying that they don't have any power, either expressly or by necessary intentment. And, my lord, I am fortified on this, my lord, on the basis of the judgeables. And, my lord, in fact, my lord, the other regulatory commissions of other states, my lord, they have themselves held that we don't have any power to impose retrospective operation of tariff. So, my lord, I am going to argue this matter.
One is retrospective operation, and what is the second point?
Second point was whether the regulatory commission has inherent jurisdiction to review its earlier order. My lord, that I am not questioning, because I am telling your lordship why I am not questioning that before your lordship is because that order which was passed and which is sought to be reviewed was passed by only one member. The two members, the chairman and the law member, they heard the matter with regard to fixation of tariff. But my lord, before the order was passed, the chairman retired. Or rather, my lord, his term expired. So my lord, the impugned order was passed by only one member. And that came up, my lord. Then my lord, the distribution companies, my lord, they made an application for review of the order saying that this particular order is really, my lord, quorum non judice. When, my lord, the order is to be passed by two members, how could it have been passed by only one member? So, my lord, that particular order was, my lord, set aside on one of the grounds being that it is quorum non judice, that particular one member did not have any jurisdiction to fix the tariff.
So, what was the date of this order, single member order?
The 5th and 6th of June, 2024. But I am handing up to your lordship, my lord, a chronological list of dates which perhaps will assist your lordship. It's a very short list of dates, my lord. Essential dates I shall indicate to your lordship. So, my lord, what is the point is this: 5th and 6th of June, an order was passed by one member consisting of a panel of two members when one member was absent, and that particular fixation was made, and that fixation was challenged by the distribution company, the three other companies, my lord, distribution company, the transmission company, they challenged it. They said that that order cannot be passed. That order was set aside, and a fresh order was passed by, my lord, the commission consisting of both the members. And that order is, my lord, dated, my lord, 24th October 2024.
Where
and
is Mr.
this
Pandey?
order,
Where is Mr. Pandey? He is not online. How much is due today?
my lord, insofar as the fresh order tariff order is passed, we are paying, my lord, from the prospective date. That's from the month of October, the bills are being raised, we are paying it. But what we are objecting to is that you cannot retrospectively say that pay from the 1st of April up to the 24th of October.
1st of April to 24th October is clear. As
per the original, yes. There is no dispute with regard to that. I have paid whatever was payable in terms of the earlier order up to October. From the month, but what has happened is this: from the month of July, from the month of April to the month of October, they have accumulated.
How much is the differential from April to October?
Yes. I shall.
Single page note.
Your lordship, I shall hand up to your lordship. Yes. My lord, kindly see, my lord, if I say so, my lord, with regard to the as per the tariff order of 11th April 2023, my lord, if I may say, just give your lordship this. These are all technical matters I hardly understand, but my lord, I shall hand up to your lordship this copy, and my lord, show to you. Okay, copy the amount. Well, there are three items: ferroalloys HT, that is high tension; industrial EHT, extra high tension; and ferroalloy EHT, extra high tension. Now, on 11th April 2023, being my lord, the prevalent tariff, which is, my lord, effective tariff, it was rupees 5 per unit for ferroalloy HT. Then, my lord, your lordship sees my first, second, third, fourth column. It was 5 rupees for, my lord, ferroalloy HT. Then, my lord, the second one is industrial EHT. It was rupees 7.5 per unit. And the third one is ferroalloy EHT. That was rupees 4.9 per unit. Now, after, my lord, the 24th October 2024, this has become 6.47, the second column. It has become 6.45, has become rupees 6.47 per unit. The second item, which was 7.5, has become 9.43. And my lord, third item, which was 4.9, has become 6.41. So this is the difference per unit.
So it appears that the Electricity Regulatory Commission has the power to review its own order.
Yes.
The single member order was reviewed by the division, by the two-member bench in October.
The division says that one member order is ineffective because it's quorum non judice, therefore that order is not effective. So, my lord, that is there. I am not going to question that. That was the subject matter of the writ. But, my lord, today I am not, my lord.
If we say
Yes.
that they will review that part of its order, giving its retrospective effect, until that time, the differential amount you keep in your bank account in a separate account. Don't take it out till the decision is made.
My lord, in so far as your lordship means, my lord, the arrear.
Yes, from April to October, they have enhanced the rate and claiming that.
Yes.
We will say that they will go into that question again, whether they have the power to make an order.
Well, I will respectfully, my lord, I quite.
Instead of this court going into that, they will review its own order.
Only thing is this. My lord, I abide by
And the differential amount, you don't have to pay them. You keep in your account separately.
My lord, only problem will be this. I tell you, lordship. What am I questioning? I am questioning the right of the Regulatory Commission to pass a tariff order with retrospective effect. It's a question of jurisdiction. I am saying that Regulatory Commission does not have jurisdiction to go into the issue at all.
No, we can also go into it, but that differential amount has to be set apart somewhere.
My lord, if you
We are not saying you deposit that with the Meghalaya Power Corporation. We can either ask you to...
But do not, my lord, send it back to before the commission.
All right. And we can also ask you to furnish a bank guarantee for that.
No, my lord, only thing is this. I shall do whatever your lordship says with regard to, my lord, the deposit of the amount of furnishing of bank guarantee.
Yes.
But what I am questioning today is with regard to the jurisdiction. Do not send it back to them.
All right.
They cannot decide as to whether they have jurisdiction to pass any retrospective order. I am questioning that under Article 226. Lack of jurisdiction. Therefore, my lord, this court has to be decided by, my lord, a writ court. It cannot be decided by the commission. It has to be decided by the writ court.
So you keep on paying as per the October determination, as per the October decision,
Yes.
24th October, as you are paying, you said. And as per from April to October, you...
Well, I am not paying. Well, I'm sorry. I am not paying as per the 24th October determination. I am questioning that. I have been paying throughout with regard to, for this period, I have paid for the 1st of April 2025, 24 to, well, the month of October 2025, I have paid at the original rate.
Yes.
The rate which was continuing.
Yes.
In respect of this period only, I have not, but subsequently from the month of October, I am paying it at the new rate.
Yes, you keep on paying.
Yes,
and
I'm going on paying.
As far as the
Arrear is concerned.
period is concerned, you secure it in some way. Pending...
But who is going to decide this one issue?
we will decide.
Your lordship will be
But some other bench will decide. It may not be possible. But we will give you that.
Well, I have come before your lordship today for the purpose of, for the persuading your lordship to decide this issue by your lordship.
No, but time is a constraint. If we had a couple of weeks, it would have been possible. But in 3-4 days, it is not possible.
Yeah, I quite appreciate that.
So the appeal would be heard out and subject to this interim order.
We shall keep it in a separate.
Yes. Or bank guarantee, whichever is suitable for you.
We are paying. Well, in fact, kindly see our predicament. These industries are in such a tight corner that they are, my lord, paying this amount under protest. Still, I am being instructed to say that. There's no question of, my lord, keeping it in a bank guarantee, for securing it by way of bank guarantee or keeping it separately. This is being paid. We are paying this amount in spite of the fact that this order had been passed without jurisdiction.
No, April to October you have not.
Yes, I am told that we have paid it. And my lord, your lordship will please to ask my lord, the commission is there before your lordship.
The order of the court is
Because
Because
my
I'm
lord,
appearing for the commission in this matter, but I do not have instructions on the payment issue, because I can only.
but you
explain
should have
what
had the
is passed, what
instruction.
has been
Definitely
passed.
I am paying.
No, the-
But anyway, my
it's
lord,
the-
insofar as
Sir,
that's
it's the
concerned,
distribution
if that
company,
is
my
your
lord.
lordship desire, if I am not paying, your lordship wants me to, my lord, keep it in a separate account, we shall do that.
No, most 100% likely retrospective effect was given and the rate was enhanced from
Yes,
April.
yes.
Now, are you paying at that enhanced rate?
Yes, I am told, my lord, by reason of the arm twisting by the commission, we are paying it.
For the back period also?
Yes, for the back period, for the by the future period, I am paying, of course, as I am obliged to. Pay.
No, for the
For the back
disputed
period also.
been dealt with by this court. This is the figure that was voted on.
Lordship will please to come to your lordship's order. The last order dated, my lord, 12th August.
12th August, sir.
The order of your lordship.
This is the dues that they said, they pointed out.
Kindly come to the last paragraph of that order. No, I shouldn't say last paragraph. Last paragraph in the second page. There, your lordship has been pleased to give the calculation. Your lordship had been kind enough to go into the calculation and has, on the basis of the submission of the learned advocate general, this order had been passed. If I may place this paragraph. In
50
these
lakhs.
appeals, kindly see 4 electricity consumers are involved, namely Pioneer, RNB, Green Valley and RNB Cements. From a table handed up to this court by the learned advocate general, the dues of Pioneer Carbide Private Limited after adjustment to the payment of rupees 50 lakhs as on 31st July 2025 is rupees 3 crores 50 lakhs. Of RNB Carbide Ferroalloys Limited, 36 lakhs 47,000 as on the same date, and Green Valley 21 lakhs so as on so date, and of RNB Cements rupees 15 lakhs 81,000 on the same date, aggregating rupees 4 crores 23 lakhs 79,000. My lord, then kindly toward the license, Meghalaya Corporation Limited. This claim is disputed by the writ petitioner's appellants. The above issue would be the core subject matter of these appeals. Mr. Paul, learned senior advocate appearing for the electricity consumers, submits that so and so have been making payments of their electricity consumption. Only Pioneer Carbide Private Limited had not payment before making payment of rupees 50 lakhs, as there has been an interim order of this court in the application for review in respect of the judgment and order dated 2nd June 2025, disposing of the writ petition where the court had directed the said licensee not to disconnect the electric supply. However, all current demands of the said licensees had been paid by or would be paid in by each of these 4 companies. On consideration of the above prima facie case, we pass the following order. As far as the alleged 4 crores so and so is concerned, each of the 4 companies shall pay their respective arrears enumerated in the above 7 equal monthly installments commencing from 1st September 2025 and payable by 10th of each month. Each of these 4 companies will continue to pay the current demand by due date. At the close of submission, Learned Advocate General submits that this chart did not include the arrears from July and August 2025. Leave is given to the respondent corporation to raise a demand on the said consumers claiming the amount from July and August of 2025. The said consumers shall add the July demand of rupees 4 crores 23 lakh 79,925 and pay it according to the above directions. The August 2025 demand shall be paid as current demand by 10 September 2025. Therefore, your lordship sees, my lord, by reason of arm twisting method, we have been forced to pay, even though we are questioning the legality and the jurisdictional issue with regard to the imposition of this amount. Pursuant to your lordship's directions, we are paying it only for the purpose of, my lord, ensuring that my electricity is not disconnected. This is what they did. So we came before your lordship and got the electricity connection, my lord, restored. Upon, my lord, this order, and this order is being complied with. My lord, let them say, my lord, if there is any other due pay, I shall secure that amount of money. I am obliged to secure this amount of money for the purpose of obtaining electricity. My lord, kindly note this.
No, are you able to secure at one shot or would you want installments?
Well, my lord,
We will couch our order in that
fact,
way.
my lord, as per their calculation, we have paid the entire amount of money. Now, after, my lord, the submissions were made, order was passed. The learned advocate general was pleased to say for the July and August 25, an amount is due and payable. Now, my lord, what is this amount? We do not know. That has not been clarified. We are in a total darkness, my lord, insofar as this is concerned, but we do not want to go into darkness insofar as the electricity is concerned. My entire, my lord, the workers' habitation is
No,
there.
but the disputed period is 1/4/24 to 21/3/25.
Yeah,
So August is the current period.
that's
You're
right.
saying that you're paying
The
according
August is not the current period. October is the current period. August is because, my lord, it becomes the past period. That is why they are saying July, August had not been.
of 24 is the past period. And
Yes.
August of 25
Oh,
is the
July,
current.
August, I do not know whether this correct 25 is correct or not.
25. It's 25 plus 9 installments.
The impugned order was passed on 24th October 24.
Yes. No, but this is, my lord, what I have understood is this, that in so far as this particular amount was directed to be paid as per the order in 9 installments. This arrear from the month of April to the month of October, this, or rather up to the month of September, this was directed to be paid by the Electricity Commission in 9 installments. So July and August 2025 is the installment which they directed to be paid in respect of this past period. So that is what, my lord, is due. This is what they are saying. I don't know, my lord, I shall take instruction whether this has been paid in the meantime or not.
We have paid one more installment after that.
My lord, after this, my lord, we have paid one more installment in terms of the Electricity Commission's order, not your lordship's order. Your lordship's order has been complied with. So far as Electricity Commission's order is concerned with regard to the arrears, 9 installment, these 2 installments were due. Of that, 1 installment has been paid in terms of it. Another installment will be paid in the month of September, the August installment. So, my lord, there is nothing in that sense of the term, my lord, nothing is due and payable to them, because, my lord, we are complying with the order, because we can't, my lord, do anything else. If we are in this predicament, my lord, we can't do anything else, because if we do something, my lord, there is in Bengali, I don't know whether my lord will be pleased to understand. কুমিরের সঙ্গে ঝগড়া করে জলে বাস করা চলে না. You can't live in the water quarreling with crocodiles. Now, normally, I am in the hand of the crocodiles. Crocodiles have directed me to pay this amount of money. I am paying these amounts of money in installment. Even though I am challenging the jurisdiction to impose this amount. Somebody has to decide this, my lord. I respectfully submit, your lordships will be pleased to decide it. But since, my lord, there is time constraint, your lordship cannot. But then, my lord, your lordship will please to protect me so that, my lord, my electricity is not disconnected. My lord, there should be a firm order that electricity will not be disconnected on payment of this amount of money. Anything else? সেটি করবে তুমি যাবে কি that you are eligible to that or should we take chance because the
Yes, please take down. These appeals were specially fixed today. Paragraph. At the outset, adjournment was prayed for on behalf of the learned Advocate General on the ground that he has become preoccupied with a matter in New Delhi. Full stop. His juniors were available both physically and online. Full stop. Since these appeals had been specially fixed, and don't interrupt at the time of passing an order. Learn this. After the order, you make your whatever you want to say. And Mr. Joyanta Kumar Mitra, learned senior advocate appearing. For the appellants. Has travelled from Kolkata to here to argue the appeal, we observed that we would allow him to commence his arguments, full stop, if the need so arose. No, second, considering the competence of the team assisting the learned advocate general, if the need so arose, we would adjourn the matter to hear the first law officer of the state. The issue in these appeals, has become extremely limited in its scope and effect. Full stop. Initially, there were two broad issues. Stop. The first was
I'll get a copy of this. You know, watch out. No. List of this.
the first arose in this way. Full stop. The order of the Electricity Regulatory Commission was made by one member on
23rd August 2024.
one member
Oh, what
on
one
5th
member?
and 6th June 2024.
Yes. 5th and 6th June.
It was challenged by the appellants on review on the ground that one member could not constitute
The quorum.
the quorum in the commission to make the adjudication. Full stop. The application for review was disposed of by the commission on 24th October.
No, 23rd August. Item 8.
Huh?
Item 8 in the list of dates. 23rd August.
23rd August
Yes.
2024. Full stop. It enhanced the electricity tariff payable by the appellants. Full stop. Furthermore, this enhancement was given retrospective effect from
Item 10.
1st April.
Yeah. Item 10, my lord, with effect from 1st April 2024.
Yes, with effect from 1st April 2024. The first issue was whether the Commission had the power to enhance the tariff, which was operating from 11th April 2023. Secondly, whether it could give its order retrospective effect. Paragraph. On the hearing today, Mr. Mitro, learned senior advocate, has not urged the first point. Paragraph. He has only questioned the jurisdiction of the Commission to give its order retrospective effect from 1st April 2024.
Correct.
Paragraph. He submits that in terms of this order and the interim orders passed by us in this writ, the entire electricity dues of the respondent corporation has been paid or is being paid by installments,
Yes.
punctually.
146. No?
Paragraph. Learned advocates assisting.
Well, sorry, my lord. I'm sorry to interrupt. Kindly, my lord, come to 145. The Commission itself had directed the recovery of this amount in 9 equal installments from all these parties.
Yes.
This is the order of the Commission itself, which is being challenged.
Yes. Yes.
And this
Today-
is by, yes.
Mr. Vito, kindly hear the order. It is
Lordship,
clear.
Lordship.
Today, learned advocates assisting the Advocate General do not have complete instructions with regard to the exact dues of the corporation as of date and the amount paid by the appellants. Paragraph. Mr. Pandey, you give a date when the Advocate General will be here.
Lords may have it on the 4th.
No, not on the 4th, after.
Lords may then have it.
Second week.
Lord,
Second week, third week, whatever.
Then, my lord, in the, not before the 3rd week of September.
3rd week. Lords may have it on the 22nd.
You wouldn't be going out for the vacation.
My lord, yes.
You-
If
you have
if
it
your
after
lordship
that.
permits me. I would-
Have it after that. What is the hurry? The interim
Very
order
well,
will be
your,
here.
your lordship will fix it. Since your lordships will not be hearing it, then, my lord, I don't have any choice. Kindly, my lord, fix any date. I give it, my lord, keep it after the vacation.
Any date, Lords, which is
When
convenient
is
to the
the
learned.
when is the court reopening?
Court
Your
is 24. Your Lordship will kindly give me. No, I don't have the. I think 24th or 25th of November.
Not November, it's
Or
starting from
October, sorry,
September.
24th or 25th of October.
Seven.
27th October, we are reopening.
Mr. Pandey, what do you say?
27th October, my lords.
No, don't keep it on 27th on the reopening day. Kindly quit any day after that. Kindly keep it on the 3rd of November, which will be 1 week after the reopening of the Calcutta.
Mr. Mitra, I will keep it on 22nd September here as to be
Yes.
mentioned. Let the date be fixed then.
Very well. Very well.
Yes, ma'am.
20 I think that is the proper thing.
It would not be possible for us to conclude hearing of the appeal today. We would also like the learned Advocate General to appear and make his submissions. In that view of the matter, let further hearing of this appeal be adjourned. List the appeal as to be mentioned on
7th September. Your Lordship.
22nd,
22nd September.
22nd September for fixation of a date of hearing. Paragraph. We modify till disposal of the appeal. We modify the subsisting interim order to the following extent only. Colon. A. The respondent corporation shall not disconnect the electricity supply of the appellants without obtaining the leave of this court before disposal of the appeals.
Lordship.
B. The respondent corporation would furnish to the appellant's advocate on record the exact amount due as of today
On account of from 1st April to
on payment of
because
the current electricity charges and arrear in terms of the
area, if any.
yes.
Eh,
No, area we said that whatever is has been paid in terms.
Area has been directed to be paid by that order in 9 installments.
Yes.
We are paying that. If there is an area, they will indicate to us.
Yes, that we said.
Your Lordship.
In terms of the orders of the commission and of this court. See, the appellants shall continue to pay the current electricity charges punctually. D. The arrears for the period 1st April 2024 till 31st March 2025 if not paid, would be paid by the appellants by 30th September. Paragraph. The disputed amount being the charges for the period 1st April 24 to 31st March 25.
Well, there is no dispute with regard to, my lord, from the month of October onwards. We are paying it without any dispute. Up to, my lord, September 2024. October, take it. 20, up to 24th October 2024.
31st March is the period.
Yes, my lord, what happens is this, in respect, we say that you have got the power to fix your tariff. When you fix your tariff, from that day onwards, I am become obliged to pay that amount.
Yes.
They have fixed it in the 24th of October 2024. I am obliged to pay, and I am paying it. I
Yes.
don't have any dispute with
For
regard
this
to no
period.
quarrel.
That we have said, the current charges you are...
Because they are
No.
paying without any protest. But the objection, my lord, is with regard to 1st
that we have
April.
taken.
And my
1st April 24 to 31st March 25. That is the period.
no, only up to 24th of October. 31st March, my lord, 2025, up to 31st March 2025, we
No,
are...
retrospective effect has been given for this period.
No, only from
Oh, I see.
24th October.
Yes.
Yeah.
That is right. Because the order was passed on 24th October.
That's right.
How could 25 be retrospective?
Correct.
Yes.
Correct.
Yes, what have you written? Till 24th October or 23rd October.
Yeah.
'24. Levied on the basis of retrospective application of the impugned order of the Commission dated 24th October 2024, collected by the corporation shall be kept by them in a separate account
Very good.
to the credit of the appellants
Very grateful to you.
earning
Yes, that's better.
the current rate of interest payable on deposits by nationalized banks. Such deposit shall be made with the State Bank of India.
And without prejudice to the rights and contentions.
Yes. In a term deposit earning the highest rate of interest
That's good.
without prejudice to the rights and contentions of the parties and subject to further orders that may be passed.
Very grateful to your lordship.
That's all.
Manoj, one submission here.
Yes.
Manoj, if this order, liberty can also be granted to me to approach to this honorable court for vacation of the interim order in case of any default.
We have said that the line will be, the connection will be continued, will not be disconnected without the leave of this court. Yes, you had right, man. In case of breach of any of the conditions of this order by the appellant, liberty is granted to the respondent corporation to apply before this court for appropriate directions upon suitable notice to the appellants.
My lord, I will get it.
My lords, one last submission is that the order may be, my lords, limited only to the amounts in dispute, and it should not, my lords, cover any other current dues which are there of the appellant corporation, my lords.
Then we are saying that
Because-
they will continue to pay the current dues.
Lords have already.
Yes, my lords. Yes, my lords.
But
That may
if,
be,
we,
my lords,
if I do not pay the current dues, they have got the right under the Act itself. I won't be able to stand in the way. But this entire order of your lordship is with regard to, my lord, the retrospectivity of this particular amount. Don't disconnect our electric supply without giving notice to us and without sufficient reasons. I mean,
Because what I am saying is that
take law in your own hand. This is what I am submitting. Unfortunate thing is this, that a regulatory commission doesn't hear us, doesn't listen to our pleas. And
Well, what
this
I'm
crores
saying-
and crores of rupees we are paying them. It is not that much, a small amount of money. And there
I am
is no
just-
complaint with regard to the earlier default on our part. There has been absolutely no complaint with regard to any default with regard to the tariff which is payable under the Act.
So, my lords, what I am suggesting is that this clarification may
We
be.
also clarify that this appeal is strictly limited to the objection of the appellants
With regard to the retrospective, nothing
with
else.
regard to the retrospective effect
That is all that I
given
am
to
saying.
the order, given to its order by the Electricity Commission, the order dated 24th October 2024,
Lordship.
and shall not be deemed to
Just
affect or influence or bind
Your Lordship,
any other terms and conditions between the parties for supply and distribution of electrical
Yes.
energy, etc.
Just minutes, one
We are not
small issue,
which
minutes. I just
question?
wanted to point out, I didn't want to disturb minutes when the order was being dictated. The order of 24th of August to October 2024, which was issued by the Commission after recalling the earlier order, is not subject matter of challenge in this writ appeal.
of course,
They have
of
only
course, that is
confined
the only
themselves
such
to-
challenge, nothing else.
Please see their prayer. The prayer is only limited to the 23rd August order. That's it. The interim order passed by the High Court. The learned
think-
single judge.
No,
And
no,
the whole
I
issue
think my learned
there
friend is
was
looking
whether
into the
there's a
wrong
power to
of,
recall or not recall.
I request him to look into the paper book which has been filed. I don't think you are
The
looking into
learned single, I participated in the hearing before the learned single judge. The argument there was only limited to the issue whether the commission has the power to recall its own order or not. That's the entire
Absolutely no.
judgment.
Absolutely no. Written notes of argument, affidavit in opposition, and recorded my lord submission.
Your lordships can see
Everything
that
is
from the
there
prayer
before the court.
in the writ petition filed before the learned single
That
judge.
your lordship will please to leave it for the learned appeal court when they hear the matter.
The interim order,
Whether I
therefore,
took the point or
in
not.
fact, I was going to say that what my friend from the DISCOM is getting recorded is expanding the scope of the appeal. The appeal is limited to the judgment of the learned single judge, which was on the power to
I shall
recall
argue
the
that
judgment.
point.
Retrospective effect was not taken.
No, but the only argument taken then was that the learned single, the commission has no power to recall its own judgment. Please see the prayers, Millers.
No.
Please see the
Absolutely
prayer
no.
of them in the writ petition.
My lord, kindly take the paper book, page 50.
No. Now the order cannot be at the beginning of the order. You write.
I know, therefore, I did not want to
No,
say
this
in
is
the beginning
ridiculous.
because the lordships are
This
protecting
submission
them
will
against the
be
DISCOM.
totally without
I'm
any
not- I'm
basis.
not
Where
involved in that.
those issues now limited to this issue. We will say
Yes.
at one point of time. There you say,
All right.
please record his name and says it submits that this issue was not raised before the learned trial judge,
Absurd.
which is strongly denied by Mr. Mitter. The point is kept open to be urged in the appeal. Yes, that's all.
এখন বুঝতে পারছো কেন আমি তোমায় বলেছিলাম?
Number 12.
I knew that this is what they are going to argue. Well, I'm very grateful to your Lordship, my Lord, for having given me a hearing. I wish your Lordship a very happy retired life, peaceful retired life, and healthy retired life.
Thank you. And on my part, I seek the blessings of such
Yes, my Lord.
noble
Yeah. Our
seniors
good
like
wishes
you.
are all there with your Lordship.
Thank you.
Lords, I'm appearing for item number 12.
Yes.
I'm sorry, though before yesterday there was a connection error, and because of rains, the connectivity could not continue, and I could not appear.
Yes.
My Lordship, this is a review petition filed by the review petitioners in respect to an order passed by this Honorable Court on 18th of February 2025. And my submission, I'm opposing that on the prima facie ground that there is nothing apparent on record which, as far as an error in the judgment is concerned. The judgment has no infirmity. The only fact which was that the review petitioners had concealed the facts before this Honorable Court throughout the proceedings was that they had disposed of the gold bangle. So in my submission, my humble submission is, there is, first of all, there is no infirmity in the order. Our order is absolutely perfect. As far as their illegalities, they are trying to cover up because we have filed a contempt petition which is pending before the trial court. I have two submissions in that, only two submissions, which would clarify the illegalities committed by them before and after both when the judgment was passed. So, my Lordship, I would just draw your attention to page number 88 of their review petition, my Lord. For a moment, please kindly see page number 88.
No. Suppose it is dismissed. What will you gain? You tell me. The
No,
gold is
Lordship,
gone.
the gold they have confiscated, that is what I am saying, has been confiscated, but the Honorable Court had passed a judgment. The Honorable Court had the knowledge that they had confiscated the gold. It is on page number 88. That is why, my Lordship, I was just drawing your attention for a moment. For one paragraph only, I would just like to read. While passing the judgment on 18th February, my Lordship had the knowledge that they had confiscated this gold. This gold was not confiscated after the judgment was passed.
That these facts, in spite of reasonable diligence, was not known to the Union of India. First ground of review, Order 47.
That is what I want to prove, my Lord. This is wrong. They were in
What
possession.
will you gain? What will you gain by this? Sending them to jail?
No, I don't want to. I'm just simply asking them.
No,
to
but
return.
what is the market value you want? If you want market value, we can direct. That gold was not there, it was not known to them. So instead of gold, this is the amount.
My Lordship, they are already willing to pay 10,72,000. That is not an issue. They are willing to pay 10,72,000.
How much you want?
I was just relying upon a judgment of Bombay High Court wherein it was held that they have sold the gold illegally. They shouldn't have sold. They did not give me a notice.
What is the consequence?
The consequences that they should have given me, they should give me the current market price. That is the only
How much according to you?
It is 21 lakhs as on the date of 18th of February 2025.
18th of February?
2025, when my Lordship had passed an order to return the gold bangle within 4 weeks. At that moment, on that day, it was 21 lakhs, my Lord.
My Lord, we have done the calculation, my Lord.
Forget the calculation.
Right.
You have done a serious mistake by depositing the gold with the Reserve Bank of India where it is lost. And it is sub judice matter. And where I think the commissioner had directed release of the gold.
And my Lordship, they do not have the authority to sell it. There is a settle. They have their own instructions on the same. I have it on my record in my review petition on page number 5. Their instructions say that they have to give a
this
notice.
has happened,
They have to,
there's no point arguing on that.
Whatever is our order. Show us our order.
My Lordship, this order is on page number 88 is the part which I wanted to read. And the order starts from page number 81. Page number 80, my Lord. And this is not the first time, Your Lordship, the Customs has done this. This has been done earlier also, and there's a board instructions, Customs instructions on this. There's a circular I have enclosed on my review petition, on the counter of my review petition, which clearly says they have to follow those instructions.
But there's a further development, my lord. The appeal filed by them, my lord, against the confiscation order, the appeal has been dismissed, my lord, on 20th of August. The departmental appeal under the Customs Act which they filed against the confiscation order.
Even in that case, Your Lordship, I have the right to file a further appeal in tribunal, Your Lord.
That 130A appeal will lie
My lord.
to the High Court. You have valued it at 11 lakhs.
But the valuation on the date we handed over to RBI, my lord, on that day valuation was 11 lakh rupees.
When it was handed over.
Even that amount they are saying is 1 lakh less than the amount when they had seized it, my lord. It was handed over on 21st of September 2023, my lord, as per their
21st September.
documents what they have, as per what they have submitted.
Our order?
18/2/25, my lord. On the date of your lordship's order, the valuation we have done is 17,16,000, my lord.
17 lakhs.
17,16,189 rupees. On 28th of February. 18th of February, my lord.
Once more, 17 lakhs.
17,16,189 rupees.
That's a good amount, Mr. Challa.
My lord, I'll be obliged.
17 lakhs.
Yes, my lord, I'll be obliged, my lord.
We will just substitute our order
My lord.
by saying since the gold is not there,
My lord.
we substitute that with 17 lakhs. to be paid. And we will say nothing about what proceedings you can take in respect of that, etc., etc.
I'll be grateful, my lordship,
But the only one, my lordship will leave that open, my lord, because the adjudication order also talks about 11 lakh rupees only, my lord, because the valuation we have done. So now since we are paying him 17 lakh rupees, my lord, and if supposing they don't succeed in second appeal under 130 also, so we have the right to recover that amount, 17 lakh rupees.
that is not an issue, my lordship. Let them. We will file till the end. We will also fight till the end. That's not an issue. It's only subject matter is whether the gold bangle has to be returned.
Your
and the
appeal
value
has
is
been dismissed.
Their appeal, my lord. Confiscation order was passed, my lord, by the adjudicating authority. They filed an appeal against that,
So they have to prefer a 138.
my lord. So, my lord, finally, in the department, if we succeed, my lord, if their appeals are dismissed, so we have to recover 17 lakh rupees, which we are paying.
Otherwise, also, my lordship, if the gold was returned to us, then also they would have recovered. It is the same state, my lord. And, my lordship, the appeal will be now filed before the tribunal, that is the Customs and Excise, Central Board of Excise and Customs Tribunal. Because the second remedy, the next remedy is before the tribunal, Customs Tribunal. That is based in Kolkata.
But not if it is a second appeal.
Yes,
They
Lord.
can be straight High
Because
Court, perhaps.
once the Commissioner Appeals
first-
passes an order, the appeal lies before the tribunal, my lord.
No, if the commissioner's order is the first order, then to the tribunal. But if it is a second, if it is on appeal, perhaps to the High Court.
No,
Check
my
it
lord, there's a slight difference, my lordship. I would appreciate to submit that. Once the additional commissioner passes an order, the appeal lies before the commissioner appeals. And once the commissioner appeals passes an order, the appeal lies before the tribunal, and thereafter the Honorable High Court, my lord.
Yes, this is an application for review made by the Union of India. Delay has been condoned
Yes.
under Order 47, Rule 1 of the Civil Procedure Code for review of our order dated 18th February 2025. Paragraph. The subject matter of the appeal was gold seized by the customs authorities. By our said order, we directed the appellant stroke applicants herein to return the seized gold to the respondent within 4 weeks
Yes,
of
my lord.
completion of our order. Paragraph. Now it is submitted by Ms. Dr. Muzika Learned, Deputy Solicitor General, appearing for the applicant, that his client had deposited the seized gold with the Reserve Bank of India. And that it has so mingled with the stock of gold kept by that bank that it cannot be identified and appropriated. No doubt, it is a serious error on the part of the appellant to have entrusted gold, to entrust a specific quantity of gold, which was the subject matter of court proceedings to the Reserve Bank of India without instructing the bank to keep it apart. Paragraph. Be that as it may, we take this assertion of the learned Deputy Solicitor General as one with relation to a fact which, in spite of exercise of due diligence, was not known to his client. Full stop. Accordingly, we review our said order dated 18th At one place you write, the gold was deposited with the Reserve Bank of India before we heard out the appeal. Deposited with the Reserve Bank of India on 21st September 2023.
No, my lordship, yes, 21st September. Sorry.
Our order was made on 18th February 2025. Then continuation. The valuation of gold as submitted by the learned Deputy Solicitor General on 18th
February, my lord.
2024 was rupees 17.
2025, my lord. My lord, 2025.
17,16,189. We review our order. Judgment and order dated 18th February 2025. By deleting the second sentence of the second last paragraph of the order and substituting it by quotation. We direct the appellants to hand over a check for rupees 17,16,189 being the value of the seized gold to the respondent within 2 weeks of communication of this order. To be taken as an amount made over in lieu of the gold. Quotation closed. That's it. The review application.
Lord, one small submission, Lord. I never wanted to interfere while dictation of the order. My lordship may kindly grant an interest on the amount from the date of the order, my lord.
Well, interest to house. Well, we are as it is. We are paying against 11-17 lakh rupees.
Lord, I'm just asking since 18th of February, not before not when the single judge passed an order, just from 18th of February 2025.
My lord, because otherwise also the adjudication is still in process. They have lost the appeal also, my lord.
But that is due, my lord.
To come back to us with the
I would have been in possession. I would have been in possession since then, my lord.
And moreover, we are giving the current value.
That would be in execution of the order. How can the court include this in the parent order?
Lords.
Madam.
As it pleases, my lord. As it pleases. As it pleases, my lords.
My lord, only one observation I was praying for, my lord. Because your lordship kindly sees page 91 if it is before your lordship, my lord. Because the adjudication order was passed 11 lakh. We will permitted to accordingly modify because now the subject matter from 11 lakh has become 17 lakh rupees.
So what will you do? What are you asking for, Mr. Mozika?
Because what happened, my lord, we valued gold 11 lakh rupees. We offered that to him. They are not accepting that. So now, since we are tendering them 17 lakh rupees, my lord, it's an enhanced value. But adjudication order, that still remains 11 lakh rupees only, my lord.
So adjudication order is different. And our order is different.
My lord, only the liberty to modify our adjudication order, my lord. The
Adjudication order, you have said that 18th February it is 11 lakhs.
No, it was on the date it was handed over to RBI. My lord.
Yes.
Because subject matter has from 11
It
lakh.
was not there prior, my lord, in the review petition. It was not
Subject
there.
matter has become from 11 lakh to 17 lakh rupees now, my lord. There's only one line observation by my lord.
What observation?
There is a subject matter, the value of subject matter will be treated as 17 lakh rupees, what we are paying now, my lord.
How can it be, my lordship? Tomorrow, the value of the gold may have increased much higher also. Now, that is absolutely, I have an objection to this, what they are saying, my lord. And that is not their prayer, my lord. The seizure of the gold at the time of seizure, whatever the value was, that is what is going to be continued till the end of this, the finality of this matter, my lord. Moreover, I am not disputing, my lordship. Otherwise, the value, according to me, was 21 lakhs as per the market value. They are saying 17 lakh. I'm just wanting to close this matter just as my lordship is pleased to pass an order and 17 lakh something. I'm really appreciating my lordship's order, and we just want to finish up this matter. We just want to withdraw
17 lakhs, how you got? 17 lakhs, how you got? You made a valuation.
By valuation, my lord. Because the gold price is going up for last 3-4 years, my lord.
No, on that day, 18th.
On 18th February, we have done the valuation as per the carat and other things, my lord. So the valuation comes to 17 lakh, 16,000 something, the same gold. But the adjudication order that was passed.
As per the market value, my lordship, the value is more, but I am still not disputing that. I'm just simply asking for it.
Then you wish to challenge that valuation?
Because now we are refunding them 17 lakh rupees, my lord. Ultimately, if we have to get back from them, my lord, after adjudication, we have to get back 17 lakh rupees.
So what have we said regarding the valuation?
Lordship, the value is more than 20 lakh of rupees. It was about 21 lakhs according to me. But I am not disputing what they are saying.
Yes.
We just want to finish this case. We just don't want to pursue this matter.
No, they've got it valued at so much.
They are saying that according to them it is 17 lakh, Lord. According to me it is 21 lakhs, Lord, as per the market value.
All right, you strike that out and write. Learned Deputy Solicitor General submits that his department carried out a provisional valuation of the seized gold on 18th February 2025, and the market value arrived at was approximately this.
17 lakh 16,189.
All right. We make it clear that the exact valuation of this seized gold from time to time, that is date of seizure, date it was made over to Reserve Bank, and the date of our order dated 18th February 2024.
25, my lord.
25 is kept open to be decided in any appropriate proceedings. If such valuation is called in question.
Grateful, my lord.
But only one thing, Lordship said.
Only nothing will happen. Why are you so nervous?
No, on that, my lord.
What?
Lordship said check, my lord, or online payment method, my lord.
Not a problem.
Yes.
No issues, my lord.
Shall make payment of so and so.
Grateful, my lord.
I'm so
Really grateful.
That's it.
Obliged.
Number 13.
They will carry it, your client will carry it to the Supreme Court, we know. but then you see what happens.
No, my lord, we are not taking it. I told them that we have made a mistake. This is like a mercy petition with your lordship, my lord. Obliged.
Well, it's this.
The claim for interest of the respondent on the above amount last is also kept open. You can ask the tribunal the tribunal or the High Court to give, yes. Because we can only substitute the parent order. Adding that would be executing that order. Yes.
Please, my lords. Well, it's this matter pertains to the pension of these teachers. My lords, by order dated 5/11/2024, had directed two things, my lords. One was, my lords, that both
Mr.
the
Paul, 13, 14, 15, the end of the list. We will take it up tomorrow if time. We will carry
Tomorrow.
this out tomorrow.
16 also, my lords, will take up tomorrow.
Call the items one by one.
My lords.
14 and 15.
What 14 and 15? 13 you call.
My lords, this was item 13.
Yes. This writ petition is adjourned for the day. That's all. Next. All 14?
14 and 15.
My lord, these are appeals from the audible. These are matter pertaining to service
Ready for hearing?
pay and allowances. My lord, these are otherwise ready, my lord. The respondents on last occasion,
Paper books filed.
we filed.
Huh?
We filed.
Which September?
My lord. It's a long matter, my lord, sometimes.
None appears for the respondents, although the Deputy Solicitor General is present for the appellants. Stop. The appeal is ready for hearing. The appeals are ready for hearing. List the same on 15 September.
My
Number 16.
lord.
This can also come up tomorrow, my lords, subject to your lordship's kind convenience. Small issue involved, my lords, had already indicated in the order.
Adjourn for the day.
My lords.
All right.
My lords have indicated, my lords, whether signing of a contract is necessary for the purposes of a contract coming into existence.
No, nothing.
Your lordships have
only
already-
offer acceptance. That is, the contract is formed. Signing is a later
It's a
act.
formality, my lords.
It's a formality.
Small issue involved. Tomorrow, my lords.
Number 17.
Tomorrow.
Your Lordship, in this case, I'm appearing for the state respondents. The
Who's for the appellant?
appellants are yet to file their paper book, Your Lordship.
You are filing the paper book.
No, the appellant.
Have you filed?
We need some more time, Your Lordship.
Direction is there to file.
Yes, Your Lordship.
We need to file the informal paper book, Your Lordship.
All right. Time for the appellant to file the paper book is extended till 15 September. Full stop. Service thereof is to be effected on advocate on record for the respondents at least 1 week before hearing of the appeal. List the appeal for hearing on 25th September.
Oblige, Your Lordships.
18.
Yes, Mr.
In which the paper books have been filed, my lord, prepared, submitted.
Yes.
Lordship, the learned counsel for respondent number 2, he's on sanction leave, Lordship.
On?
Sanction leave. Leave. He's on leave.
So you talk to Mr. Chakraborty when he wants the appeal?
Well, it can come up in
Second week of September?
third week, my lord.
All right. By consent of learned counsel for the parties, list this appeal for hearing on 23rd September.
All right.
Obliged, Lordship.